Good morning, all. Agent McMahon here, State Rep McMahon, calling this meeting to order. And this is the subcommittee relative to House Bill 535. And with the goal today is reviewing information provided to us. I want to thank the parties that did some serious work on making some recommendations for us to discuss. So thank you very much for responding from our last meeting and making something happen while we're young to consider. And we'll be moving forward on this to see what recommendations or what direction we collectively come to a consensus on. And with the goal that on the 31st of October is when the full committee will be meeting to act on the recommendations of the various, on the 10 retained bills, 535 being one, on recommendations to the House for action. So that being said, we'll start our discussion right here for our subcommittee members. And we normally have 6, but 2, Rep. Grossman and Rep. Seidel will not be in attendance today. So I wanted everyone to know that they wouldn't be coming in late. The ladies were not able to make it today. So that being said, we'll open this up to a discussion from members and see what the thoughts are based on information that was sent out yesterday that we received, and also there was and again from Ms. Rosenberg and also from Ms. Sink relative to recommendations to us. And did everyone receive both of those on their emails?
Yes.
I want to make sure that we're on the same page. And I was having to ask our support staff, our authority having jurisdiction, provided the documents that are in front of you that we to help us as well. So that being said, let's start our discussion. What comments do our members have? Representative Long.
Thank you, Mr. Chairman, and thank everybody for their work and trying to resolve this. So we're looking at 2 amendments. I was wondering if we could speak to someone from each side to see where they agree. My understanding is there are some issues of agreement, and where it stands out that there's not the agreement, and that's something that we'll have to peel the onion on and see where we slide with that. So I don't know if Ms. Sink, if you could come up to explain actually it'd be the chairman to call you up, and somebody else from the other negotiators. Yeah, it's up to the chairman.
Well, yeah, we want cooperative collaboration, so both of you come up,
Okay.
if you would. Do we need another seat? Need another seat there?
We can have people on deck if needed. Me too.
Good afternoon. Thank you for the opportunity to be here today, and thank you for the work that you're doing on this. I guess I'd like to start by saying that I'm Marcia Sink, CEO of CASA of New Hampshire. That it's been a lot of good work that we've gotten done over the past several weeks at your suggestion, Chairman McMahon, and we came to consensus on many things, but there were a few obstacles that got in the way of us being in completely on board with each other's ideas, suggestions, and recommendations for the change to the statute. So I just wanted to start by saying that I think there are people that put in a tremendous amount of work. I know there were people that put in a tremendous amount of work. I think the challenge for us was the actual implementation of some of what has been suggested by the folks under the just JRBG group. Sorry. And I just know them by their first names primarily. So, but that just without the court's involvement in this process, more heavily involved, and that of DCYF, that those are the folks that are really going to be the ones in charge of making all of this happen for our kids and the courts. So that's when we, I think in the end, decided that we couldn't be in agreement with everything, and we wanted to go back to what we had offered last session, was just that minimal change to the child protection statute that opens the opportunity for the discretion of the court to appoint an attorney at any stage of the proceedings. The way it currently reads now is we are limited to when that request can be made, and it's typically made by the guardian ad litem. This offers the opportunity for any party to request it, and at any point in those proceedings, so that a child who maybe at the dispositional phase didn't think we needed an attorney, but further on in the proceedings at a review hearing, or if the child was in residential placement and things like that, and it was extending in time, that the request for an attorney technically could not be made, although some of our judges have felt it was critically important that they do make that appointment at a different point in the hearing. This allows them the opportunity. Again, it just broadens that, so we went back to that original language because we couldn't come to full agreement on some of the other pieces, I guess is the fair way to present it.
Before
Yeah.
having just a clarification, Ms. Sink, and appreciate you sending out the email this morning.
Yes.
A comment that struck out with me, and wanted to just get your guidance for all of us here, where it's stated in the email that DCYF and the judiciary were not part of the discussions regarding the proposed language. That being said, is there not inherent conflict then on what would be recommended as it goes through the quote process, that if they weren't given, that those two entities weren't given the voice as part of this, that there would be a challenge in having it supported?
Go ahead.
It's our understanding that the judiciary does not weigh in on policy, but that we thought it was important from an administrative standpoint, not necessarily, and the division we know often does not take a position on certain legislation, but we do think it's critically important for both the judiciary and DCYF to at least talk us through how this would work administratively. I think specifically with the legislation, that's one of the sticking points was children who are at risk of being placed in a residential facility. So if you look at the proposal, the amendment to 169C10(2)B, and Chairman McMahon, you asked Representative Long, where did the parties agree? I think we came to a point where we could agree that children who are currently in a residential facility should be appointed counsel. The problem was the rest of that paragraph was, how do we determine children who the division may need to place? And that was really, the more we looked at this language, the more complicated it became. And this is the kind of language we think specifically that the judiciary and DCYF talk us through when the division suspects they need to place a child in a facility. What does that look like? How could that look like? How quickly could the judiciary respond to this? So to answer your question, no, they can't weigh in on a yay or nay, but to let the parties better understand how the people who will actually have to implement this law day to day, how this is going to work. And so we think that their voices were critical. So that in particular, that whole language after that starts, except in the case of an emergency. And there was agreement on from the other side that if the division, I'm actually looking at the language that Karen Rosenberg submitted.
Okay.
I've got.
Is that 2B?
Oh, 2B, okay, right here, yeah.
So everything, starting with accept and everything down, we thought was clunky and unclear. and difficult to administer. And frankly, it's our position, it's CASA's position, we don't have the resources to support this. I mean, I know this is a policy organization, but this language assumes we have other foster families, we've got other other relative placements, and we have attorneys. I mean, that's remained a concern that right now we do not have a system in place to support this legislation. We wish we did. We really wish we did. It's our concern that if legislation is enacted without a system to support that children, that this will not be good for kids.
Representative.
Thank you,
Right.
Chairman. I just have one question because I want to understand you guys. And by the way, thank you all for being here. When I think about, who's protecting the children in our communities, you guys are all the heavy hitters. So thank you very much for everything that you do. So when I look at this and I hear you that the resources and stuff, I want to understand more like of that groundwork. Whenever you have a case where a kiddo you find out that they might be placed or that this is going to happen, what does that time period look like? Because I'm seeing like 2 days and stuff. Like I know I have friends in other areas that are foster parents and it comes up very quick, like within an hour. So what does that timeline, what would language like this do with that timeline?
And I think that's exactly the concern, is we haven't defined what an emergency is. Is an emergency that the child is setting fires in the foster home, that the child has killed the foster family's pet? I mean, what an emergency look like in our cases is it depends on the child, depends on the home. And that we think that the division does need to respond pretty quickly, and depending on where the child can go, it depends. The challenge with looking at the children at risk or children who the division is contemplating, it's more subtle than that. It's the family is not accepting of the child's sexual orientation, or the child is allergic to the family pet. The situation where we know it's not a good fit, and we know the child needs to be removed, but gosh, we don't have a place to put this child. We don't have another foster home. So we feel the division needs to be able to have its statutory authority to be the child's custodian, to temporarily place a child in a situation to prevent the escalation and dysregulation that could occur, that could not be harmful to the child, to leave that child in a situation that is not in the child's best interest.
And I think to add to that, this was really intended for children who are at risk of placement in a residential facility. So it's not necessarily just about moving from one foster home to another, but it was being able to identify those kids at risk of being placed in a residential facility.
Thank you. So in a residential, like what does that, I know that each case is individual, but what does that typically look like as far as what's your time frame from the time when you find out? Like I just want to be very pragmatic about, if you had resources, like what would this bottleneck things? What, in your opinion, and I wouldn't mind you guys answering as well. That would be great. But I just want to understand and not complicate the timeline from
Thanks.
when these things need to happen.
For the record, I'm Karen Rosenberg. I'm the policy director at the Disability Rights Center, and I'm a member of what's known as the Juvenile Rights Policy Group, and that consists of New Hampshire Legal Assistance, Waypoint, New Futures, the Children's Law Center of New Hampshire, the ACLU of New Hampshire, and who did I forget? Got it all. So 6 organizations who all stand behind the amendment that I emailed to the committee yesterday. And in part, I want to just remind you that at the last committee hearing, the work session, the members of this committee expressed a desire to not do this halfway. There were big concerns about children who had been placed at Bledsoe, a really dangerous facility. And those children were not represented by counsel. And although, it is one thing we all agree on here is the importance of CASAs and how valuable their role is in these proceedings because they form really good relationships with children. They they are talking to DCYF, they're talking with the parents, but they're not attorneys. They have attorneys, but they are not attorneys, and it can be very difficult for a volunteer CASA to secure records at an away facility, to have contact with their children when they're far away, and having a child's appointed counsel can make a big difference in terms of cutting through a lot of bureaucracy and asserting the child's rights under the law. So I think that one of the things that this committee directed us to do was to look beyond the court's discretionary authority to appoint counsel and see if there was a way to come together with all of our organizations and decide and come up with some language that would address the risks and real harm that children may suffer when they are unnecessarily placed at residential facilities. And so that is what we attempted to do. Now, it should be noted that the courts were actually invited to we met twice in person following the committee's meeting, and the courts were invited to participate in both of those meetings. Erin Cregan did participate in one meeting and was, I think, unavailable for our second meeting. However, she informed us really clearly that the court was not able to take a position or not going to take a position on an amendment. She provided some information to us that was really helpful in in terms of how they would respond to legislation that might come out. So it was helpful to have her there. We did not invite DCYF to the table, in part because we've been informed by their counsel in the past that they are not taking a position on whether children ought to have counsel appointed in abuse and neglect proceedings. And for reasons that you discussed, it might be challenging. It was already challenging. We worked really hard to try to get to yes with all of our organizations. And that would add another wrinkle. However, we did look at DCYF policy about how placement decisions are made and what their procedures are. There are people on the JRPG, not myself, but Lisa Wolford and Michelle Wangaren, who represent children in these situations, who drew from their own experience. So we did have, and of course, CASA also has a lot of experience dealing with individuals and children in these situations. So we really don't think that the fact that DCYF was not at the table is really a barrier to this committee making an informed decision about how to proceed. So that aside, the object here was to broaden the court's discretion, which I think we did pretty easily agree on language that would broaden the court's discretion to appoint counsel. And I think that, when we spoke about it, as Caroline Delaney mentioned to you, we did agree, and that it was pretty easy to say if kids are in residential facilities, they ought to have counsel appointed. We agreed in principle on the idea that when children are at imminent risk, not just a thought of risk, but that there was definitely a real risk that they might be placed in a residential facility, that they ought to have counsel appointed. And so we did our best to define what that was. And in doing that, what we did was we looked at DCYF's current policy on when they, what the procedures are when they think that it's possible that a child's needs cannot be met in a foster family or kinship home or in their parents' home, and a residential placement should be considered. And what DCYF policy says is that they should refer the child for an independent assessment, where they're using is the CANS. So we use that as one touch point for when, because they are knowing that they're going to be referring the child for an assessment, and the purpose of that assessment is to make a determination: does the child need to be placed in a residential facility? And in part of that decision goes to what the child's emotional mental health needs are, as well as to whether those needs could be met in the community. So we thought that was a touch point that we could agree upon. When DCOF decides that they are going to be referring someone, that they would notify the court of that fact. So then the court could go and appoint counsel. It didn't, the other thing that our group felt was important was to also consider when as a touch point, when DCYF sends packets to facilities. Because what we've learned in our experience with children is that oftentimes DCYF doesn't follow the policy of not sort of holding back on a referral to a residential placement until they've our perspective and considering when counsel ought to be appointed for children. We've considered that children are also at risk, not just when DCYF is considering doing this CANS assessment, but also if DCYF is actively referring children for consideration for admission to a facility. So that appears in this amendment. And what would happen in this amendment that we're asking you to consider is that at that point, DCYF would notify the court that they are pursuing possible placement either through the assessment or through referring children by sending their individual information to facilities, and then it would be up to the court to appoint counsel. There's nothing in here that says that the placement is held up, however. And we understand that it could take time while we are developing attorneys to represent children and training them and making sure they're prepared. There might be delays. But we're setting up a statute that is going to be not for just today, not just for tomorrow, but for into the future, for how children's rights and their best interests are going to be protected. And it's a little bit of a chicken and egg situation. If we don't do anything to guarantee a right for representation for children at their most vulnerable stage, when they are at the highest risk of being ripped out of their schools, ripped out of their communities, removed from their homes and put in an institution, if we don't get that into law, then we're never going to develop that pool of attorneys because they won't be required, right? If we require them, then we're going to develop that pool of attorneys to represent children. In emergency situations, which we did not define purposely to allow for some flexibility, a child can be removed. A child can be removed from a dangerous situation, and the court wouldn't get notice of the child's removal, even removal to a facility, a residential facility. They would, after the child is removed from that facility, would be when DCYF would notify the court, and then at that point, the court would appoint counsel for the child. But there was no intention to leave children lingering in a dangerous situation. All that we intended to do here was set up a framework for when DCYF would notify the court that either the child is placed or at really high risk of being placed in a facility. And then it would be up to the court to appoint counsel for that child. Another thing that we thought was really important that's also in this amendment is that with regard to those discretionary appointments where a child might, with this expanded discretion, be able to ask the court to appoint counsel for something other than a placement, a residential, a facility placement. Because that's another right that the child would have, and there is a foster care children's bill of rights, we felt it was really important that the foster care children's bill of rights be amended to reflect that additional right that a child would have to simply request appointment of counsel. It's not a guarantee that they would get counsel, but at least they would be informed, as they are informed about a whole lot of other rights, like the right to have team meetings and participate in team meetings, right to normalcy, all the things that are in the Foster Children's Bill of Rights. We felt it was really important that children be notified when the rights have been expanded in some way. And that also turned out to be a bit of a sticking point, I think because of a misunderstanding that our organizations had about the import of that. So I don't know if that's a long-winded response and probably didn't even answer your question, but I'm hoping it was helpful.
Was it helpful, Representative Gregg?
So how could that not be helpful? It was. I'm not even sure that my question needs to be answered at that point now, because in reading that and kind of understanding. But yeah, thank you for that. It was all helpful. All the information. By the way, I mean, we sit on a committee where half of us agree sometimes and half of us don't. So we certainly understand how disagreements can happen with the best of intentions. So, yeah, I don't have any further questions right now. I'm still like absorbing all that.
If we could just take a moment to respond, CASA, I mean, again, Attorney Rosenberg and I were up until the end of the day on Monday. We've been talking a lot on this with respect to the adding to the Children's Bill of Rights. That was something that CASA had agreed to, but what did not make the proposal, and the reason why we couldn't fully get behind it, was an issue that we brought up at the last hearing. We wanted inclusion in the amendment that children and their attorneys cannot participate in the adjudicatory hearing. And we had raised our concerns about this at the last hearing, that children, that parents could try to manipulate their children, that a child would be faced potentially with being either feeling they need to lie on the stand, or forever feeling guilty that it was their fault that the division got involved with their family. And children do feel guilty about that, that if I hadn't spoken up, that maybe, that DCYF wouldn't be involved with my family. And so it's CASA's position that the parents, that the children should not be involved in that initial hearing in terms of contesting whether or not they are an abused or neglected child under the law. And one other point, that I believe that there may be a misconception that every other party in these cases has an attorney, and that's not entirely accurate. It is only, with respect to right to counsel, it is only a parent who is the petitioned parent has a right, an indigent, to be appointed an attorney. So in the case of a father who has never been involved in the child's life or minimally involved in the child's life and is not the petition parent, meaning he is not the parent who is responsible for the abuse and neglect, does not get appointed an attorney if he is not a household member. And I respectfully think that's something the committee should look at in terms of every parent having an attorney in these cases. We also have women who are victims of domestic violence, who, if they are not the party responsible and they are not a household member, father has been removed, she, in some cases, is not appointed an attorney. Even if we have filed CASA a motion saying, listen, it's in the child's best interest if mom can come to the hearing and talk about how the kids are doing, and she's told the court, I'm too afraid of my abuser and I'm not going to open my mouth. So we think everybody, it would be great if everybody had representation and everybody's rights are being protected. We just think there's a whole lot here, and that a good first step would be to allow those kids, both in residential, both who are where the case really warrants it, to have judges have the ability to appoint lawyers now for those kids. And then we are ready, willing, and able to continue to have late night conversations and to keep going back and forth and hopefully find something that will work best for New Hampshire's children.
Representative Long.
Thank you, Mr. Chairman. So, I mean, I'm of the opinion, and I'm not in the trenches as you all are, but I'm of the opinion that the adjudicatory hearing is one of the best, has the potential of driving this child to where their future is going to be at that decision. So I wonder why you sense that an attorney should not be representing a child. I'm not talking about a parent's. I'm just in regard to the child, and I'm not talking about the child being there. I'm talking about the attorney representing the child at these proceedings. Why would that be harmful?
In some cases, it might not be. It raises, if the child is represented at the adjudicatory hearing, we do think, and this happens, where parents' attorneys try to subpoena children to testify, and where parents will say, my child is lying, my child is exaggerating about the abuse. And it's the worst cases. It's the sexual abuse cases. It's the worst physical abuse cases. If we do have a concern that even if the attorney is there, that that parents will try. Well, you can protect the child in the adjudicatory hearing because the attorney will be able to jump up and object. I mean, right now, there isn't a proposal to keep children from coming to that hearing. And I will also say that RSA 169C18, the adjudicatory hearing statute, only addresses petitioners, typically the state, and petitionees, the parents. So there isn't anything currently in the adjudication statute that that even suggests, including CASA. I mean, the guardian ad litem also in that statute is not included as a party that presents evidence or cross-examines witnesses. So that statute needs to get changed as well if there's any suggestion that children attorneys are going to take an active part at the adjudicatory hearing.
So if one of the parties is looking to subpoena the child, does that happen even if though there's an attorney not there? I would think.
Yes, and CASA files a motion to quash. We file and we're successful, saying it is not appropriate for the child to be subpoenaed to testify at the adjudicatory hearing. There's a New Hampshire Supreme Court case in Ray GG that talks about the policy reasons behind why we keep kids from hearing. I mean, even though they're the victims, to needing to be a part of litigating this.
I'd like to interject. First of all, I think that when you look at the adjudicatory hearing, one of the things that is at issue is family integrity. That is a very important right and one that the child has a real interest in. And a lot of children are not going to want to have anything to do with these adjudicatory hearings. But if they happen to be appointed counsel and they want their counsel to weigh in on that, basically dissolution of their family potentially, that seems very appropriate. And that if you have appointed counsel, it would be a violation of the child. It would make it impossible for counsel to actually do their jobs if they were prohibited or presented with barriers that other counsel don't have in hearings. Secondly, that the case that was raised, INRI GG 166, New Hampshire 193. Basically, in that Supreme Court case, a father did try to subpoena his child, and the Supreme Court and the trial court said, no, you can't. You're not going to be able to subpoena the child. We're not going to have the kid here. There was a video testimony, and that's good enough. The Supreme Court ended up taking that case and basically said it was appropriate for the court not to require that child to testify, that 169C is about, in large part, determinations about what's in the best interest of the child. And then the court went on to talk about factors that courts ought to consider in determining whether children ought to be brought in to hearings. And that would include things like factors would include the specific potential harm to the child if they were required to testify, whether or not there are alternatives to in-court testimony that would provide the information that the other party is trying to elicit. And nowhere does this decision say that children should not participate in any portion of the decision. Courts have discretion, and it's in the court protocols. They have discretion to determine whether a child ought to be able to participate in any one of these proceedings, including the adjudicatory proceeding. There are federal funds that are available, not a lot, so don't start spending them too quickly. But if we wanted to take advantage of them, 4E funds, which are federal funds, are available to defray the cost of representation. And what all the policy and rules say about the implementation of 4E funds and using them for this purpose is that those funds are available at all stages of the proceeding. It does not say that, if the children cannot participate or have attorneys to participate in these hearings. So it would really, of the 38 or so states that have fully established rights to counsel for children, none of them say that the child cannot have counsel at adjudicatory hearings. So, if we were to adopt a policy like that, New Hampshire would be an outlier. Like I said, I don't know that this would come up very often, but to hamstring an attorney, prevent an attorney from doing, what they would be required to do under rules of professional conduct when they have a client, the child, I think would really be a disservice to everyone.
Okay, to follow, if I may. In your experiences, have you seen where a judge would subpoena a child and have the child speak? Or is that rare or none?
I only, thus far, I've had one case. It was a physical assault case where a mom allegedly broke her teenager's jaw, and the mom wanted, like a criminal case, was alleging self-defense. And it was before the statute was changed, we were successful in keeping the child from being required to testify at the family court proceeding. At that time, there was, we had de novo appeals to the Superior Court, and the Superior Court judge denied. I had filed a motion in limine that to prevent the child from being required to testify, and in that case, and personally, I think it's because Superior Court judges weren't accustomed to seeing a lot of family cases and also see more criminal cases. But that we have had one case where that was required
All
for
right,
the child.
so I'm looking to get a clear indication as to why it's problematic with an attorney in the adjudicatory hearing. One of them was with respect to subpoenaing a child.
I mean, if the child, if for the attorney to be there, I mean, for example, CASAs do not participate, and private guardian ad litem's do not participate in the adjudicatory hearing. They are not referenced as participants in the adjudicatory hearing statute.
Are they
but we
present?
go.
Could they be present?
They, of
Okay.
course,
Yeah.
they are present. They're present at the preliminary
Okay.
hearing, and they're present to certainly hear all that information. And we're not saying that children's attorneys, if they've been appointed an attorney, should not be present, but should not participate in the adjudicatory hearing.
Okay, and if I may ask Ms. Rosenberg a question, having the attorney present, in my opinion, would give the attorney the the upper hand to know what's going on, so that he could immediately represent the child, knowing what the discussion was all about. What's important to you where the attorney has to be part of the
Well,
adjudicatory
what if the evidence does not indicate that there actually was abuse or neglect, that it's not, that really, let's say it's poverty, and the child wasn't connected, the family wasn't really connected with the kind of resources that were necessary so that the child could have adequate nutrition? Or what if it was something else is going on? The attorney's participation could be critical in the court's ultimate determination about whether the petition should be founded, or whether there ought to be other services looked at or put into place rather than a founded petition, which could, these decisions have a ripple effect. Okay. So I think, off the fly, it's hard. I think some of my colleagues might be able to come up with some other examples of where having an attorney could be important to children. Like I say, I don't think it will come up very often, but to basically prohibit this up front instead of relying on the law that currently exists that gives courts discretion about whether children participate in any of these proceedings or whether their counsel participate, we don't need to touch that with this amendment.
Okay, so the intent of what I'm hearing is there's another statute that would have to be changed, because the intent is with the petitioner, with the two parties, which of course the children are brought up. So that's where I'm trying to define the importance of the attorney being there. I lean towards yes. It's important if this attorney is going to represent that child going forward, that in every aspect they should be there. I'm in the middle of just being there, allowing an appointment of an attorney to be present, at minimum.
Yeah, if I could respond to two things, I think the cases that we see, and as you know, we see hundreds of these cases, and we're involved in hundreds of these cases. It's very infrequent that when a child is removed or when a petition is filed, that it is for things like neglect, not being fed well, or poverty. DCYF investigates, investigates, and investigates, and reports are made and reports were made. If anything, we see the reverse of that. We see petitions being filed that should have been filed much sooner. And it's very rare that it is just that a family is in need of services, because there are other referral opportunities, and there's a lot of work being done statewide in the whole prevention arena, so the kids never even show up in court and the families get what they need in advance, because it is a horrible experience for everyone involved. One of the things that could potentially happen, and I'm not an attorney, so these guys speak to this better, but I think if the attorney at the adjudicatory hearing is representing what their client wants, their expressed issues, and if that 12-year-old little girl who's been sexually abused repeatedly by mom's boyfriends, stepdad, says, I want to go home, I really want to go home, it's up to her attorney then, if they're at that adjudicatory hearing, to say, my client wants to be returned home. It's clearly not in her best interest to be returned home because mom can't keep her safe or for whatever reason. But he needs to argue that point to the court if he is truly advocating for what his client wishes. And I think that's one of the complicating things that could get factored into the adjudicatory hearing. I mean, we have had so many cases where kids do want to be returned, but it isn't safe. And if that attorney is representing what their client wishes, which is what their role is, that gets messy, and it puts kids at risk of being returned to unsafe homes. So
Okay. So would you be okay with an appointment of an attorney prior to the adjudicatory? However, they wouldn't participate, but they would be present. That's not an issue.
I don't think so.
I don't think so. No, no, we don't think so. Hang on, Karen. Jeez.
Okay,
Okay.
thanks.
Thanks.
I know, I'm a lot. I mean, I think there's a big difference in being at a hearing and having your hands tied and not being able to represent your client's interests. And just because a child has an attorney appointed who represents their client's expressed interest doesn't mean that the attorney's going to win, right? We know that basically it's just going to raise the level of the discussion and what the court considers. So the court will hear from the CASA, who will present all the facts.
We don't speak at
I'm
the
sorry.
adjudicatory
They'll hear from DCYF. Excuse me. I stand corrected. Thank you. Who will hear the petition and all the facts that they're relying on. They'll hear from the parent, and they'll hear from the child's attorney. And the court will make a decision, having heard all of the arguments. And it, as Marty discussed, where there are, very detailed investigations, where decisions maybe should have been made a long time ago, and there's multiple incidents, the courts will hear that. And when if the attorney happens to be appointed because the child was placed residentially and the child says, I really want to go home, the attorney will engage in a discussion with their client. The attorney will say, here's what, if they're doing their job, they'll say, here's what the evidence shows. I'm really sorry, but the evidence shows that you've been victimized 20 times over the last year, and you sexually assaulted and all these terrible things, and that all of the interventions that were done on a voluntary basis didn't work. And so the court probably isn't going to say you can go home. But let's talk about what what else is going on here. Maybe there's some other solutions. And so maybe what the attorney would do is look at, did DCYF do due diligence in looking for kinship placements as an alternative to a facility? Because remember, we're only talking about children now who are in facilities. Did DCYF really exhaust foster families as a potential source? Is the facility that you're placed at even appropriate? Is there another facility that's closer? Are these things that you might consider? And they might be able to actually talk to their client and get authority from their client to express the client's desire to return home, but maybe with some interim steps. So it's not black and white. But what this does is it presents an opportunity for the child to feel respected, that their opinion is respected, that what they say matters and what they care about matters, to have it fully considered by the court. because if their attorney is there, even if the attorney tries to get talks to their client about what they think, might be reasonable or that the court might order in lieu of, instead of bringing them home, and they make the argument and the court doesn't do that, the child is heard, the child is empowered in this situation where they've been completely out of control, where their world is upside down, where really, even though they're their abusers, their parents are the only parents that have been their parents, at least they've been heard and can be empowered by this. But if their attorney has to just sit still idly, it's okay. I'm glad I'm not the only one. We're both grabby people. I'm worse than she is. All right. I admit I'm worse than you, Marty. If that at least the child will be heard and the judge will make a decision about what needs to happen. And like I said, attorneys don't always win.
See, but I'm thinking of the potential of conflict with the child and their new attorney. Also, if I mean, I don't believe, again, I'm not the experts as you are, but I know there have been abused and neglected children that want to be with their parent. It's their parent.
That's all they know.
You know?
And
Yeah. So I get that.
right.
And for an attorney who's the child's being told that they're going to represent your expressed wants, what is it that you want? And I say, I want to go with my mother. And he explains to me, well, your mother hasn't done a good job so far, in a nice manner. That may diffuse the child's feeling that this person is representing me. And we want the child to feel like they're empowered. Okay, I have somebody who has my best interest. So I don't know right from the get-go if I tell I want to be my mother and they explain to me that it's not a good idea, that I would be like, wait a minute.
Yeah.
Yeah.
If we could just back up again, we were in complete agreement about children who are placed in residential facilities should have counsel.
Yes.
Period. The end. We're in agreement with that. Where we got stuck was that appointment happened at adjudication. So there's a lot of consensus, but that was one of the points to Representative Long, because that could potentially complicate things for the child. But that attorney representation, if they're in placement, is absolutely, we support that. We think it's important. And so that and primarily it's youth that are placed in residential facilities, that they have a voice in that proceeding, that they have an attorney standing by their side. They also will have a CASA standing by their side or another GAL. So, but I think that was one of the sticking points, was that when the appointment of that counsel occurred.
Right. So in my mind, I'm thinking not necessarily when, but participant or present. I mean, as far as the adjudicatory, present is okay. Your issue was participating.
And we actually have language that we could forward that was an amendment to 169C18 that specifically stated that if an attorney is appointed pursuant to C10, that they would not participate at the adjudicatory hearing. That was language we asked to be included just for this issue, and we understand reasonable minds disagree all the time, but this language did not make it into a final consensus draft. But if that is important to the representative, we could forward that.
Okay.
Anything further from the individual to your right, Madam Singh?
Thank you so much. Lisa Wolford for the Children's Law Center of New Hampshire. They've covered a lot, and so I don't want to retread old ground, but I will say, because the statute now, the Child Protection Act, does not weigh in on whether counsel or the child should be present at the adjudicatory hearing. I don't think that's something that you should be concerned about. I think it is best to leave the statute as is, and as is that the statute does not address who should be at the adjudicatory hearing and who should not. It is accurate that 169C 18.3 talks about the matter being adjudicated, so whether the parent is neglectful or abusive, and refers to the state and the parents so if a child's lawyer came to an adjudicatory hearing because their child wanted them to be, their client wanted them to be there, and their client wanted them to participate in the hearing, the attorney presumably would let the judge know that that was their intention. They can't just barge over to the witness, they can't just start calling witnesses, right? So I think that this is a determination that our judges are equipped to make. And I think in the first instance, we should leave it to judges to make those determinations. I mean, I don't recall the amendment that, so yesterday, apparently we talked about it yesterday, but that flew over my head. That is something that I don't think makes sense and would not agree to. If I understand it correctly, and it's not before you, it has not been proposed to you, but as I understand it correctly, what Attorney Delaney was saying is that the proposal was an amendment to C-18-3 that would exclude the child and their counsel from the adjudicatory proceedings, which we think, for the reasons that you've discussed, Representative Long and Attorney Rosenberg have addressed, are not appropriate, because we do think children, when they decide that they want to be there, which is not going to be every case, and so we're talking about a limited number of cases, right, and a limited number of kids who want to participate, but when they decide they want to be there, they should be empowered with that presence at the time when a fundamental decision which will profoundly alter their lives is going to be made.
Right. And if I could just give one more follow-up question on
Please
that.
do.
Do you suspect that there will be more children, knowing that they have an attorney, that would want to go to an adjudicatory hearing, and that would be a concern of mine? I'm thinking, I'm 12 years old, I got an attorney, I'm stretching my suspenders, and yes, I want you there, and by the way, I'd like to be there myself. But you're saying that won't necessarily be the case.
There's no guarantee.
I think that's right. There isn't. I mean, I have clients who don't want to come to court, and their CASAs beg them to come to court. DCYF wants them to come to court. The judge wants them to come to court. They don't want to go to court.
Okay.
I have clients who do want to come to court, and I file motions to ensure that they're transported.
But I think the difference at the adjudication is that's where their parent, it's like a trial, right? That's where their
Right,
parents,
right.
and for them to potentially witness that,
Yeah, I don't.
I think that can add just another trauma to the traumas that they've already experienced. So I guess that's why we struggle with this appointment at adjudication. Because if the attorney, if the child who is like a client of the attorney wants to attend, the client really has to do what their client is directing them to do. So.
Right.
But the judge doesn't, right? And so INRI GG, happy to give you my one copy, which is in my binder, but INRI GG makes very clear it is up to the judge whether the child testifies, and presumably the judge could also decide, and maybe there's a legal argument about the child's rights, whether the child has due process rights to attend versus the judge's determination of their best interest. But INRI GG, in that case, that child, DCYF represented to the family division, or it might have been a Superior Court case, but represented to the trial judge, that the child's therapist would provide testimony that the child should not be present in court and should not testify. And the Supreme Court said that is great. Judges should make those determinations and take all of that information into consideration.
Agreed, if given the opportunity, right.
Well, the judge will always have the opportunity.
I understand that. I think if a child a child could be present but not necessarily be required to testify. And just being present in the courtroom could be traumatic for the child.
But the judge can make a determination about presence.
So
Understand.
am I witnessing how your conversations went these last couple of weeks?
It's complicated. It's very complicated. And you wanted something simple, I believe, Representative Long.
But I'm still not sure why. Well, I get that. I guess that's what CASA wants. I mean, I think the agreement is that more children should have lawyers. Children who are in placement should have lawyers. And then children, we believe, who are at risk of placement, risk being defined the way we've proposed, which we think is clear, which relies on the language of DCYF policy 1615. Those kids should have counsel. The issue about the adjudicatory hearing is one that every judge in every case can decide.
And at risk of placement means residential placement, just so we're clear. Right.
Anything further from members?
Other people, but if I can,
Thank you.
Mr. Chairman. Yeah, I wanted to clarify. I got a little more clarification on the risk of placement of residential placement. So that's clear there. So it's residential placement. With respect to cans, what you know, when a child in an emergency is placed in a residential placement, and they are going to do the cans assessment, what is that time frame? Because is that sort of a child in limbo, or what is the time frame of this assessment? When would the courts get an assessment?
You may approach the bench, Ms. Mulford. Yes, yeah. Just get comfortable there, will you? Okay. Thank you.
Okay. And in anybody's experience, has that been problematic? I'm sure it has been a few times, but percentage-wise, is there a lot of there was a lot of added trauma to children when they're waiting for 30 days in a placement, and then maybe some of the assessments say, you know what, I think we have a foster family that would be able to take this child. Because my understanding is those CAN assessments, do they do levels? Okay, and my understanding is some of these placements, when you give a level, it's a turnoff. Yeah, no, we're all set. We're not interested. So I'm wondering if after an assessment, has there been reconsideration for whether a foster home or a family member, or do you know?
And the CAT, it's the CAT assessment, the Maximus CAT, not the CANS, which is a different assessment.
Yeah.
But where the CANS concludes that the child does not need to be removed and put in placement. In my experience, the kid was not removed, so the DCYF was waiting for the CAT assessment result before moving the kid. I mean, DCYF should be referring kids for CAT assessments if they believe that the child's needs indicate residential placement, and that should be done prior to a child moving. I think probably, and maybe others will have other information, but the times during which the CAT is done after placement are those emergency placements.
Okay, yeah, I'm just trying to get my arms around the emergency placements. That's seems a little problematic.
So I agree with Attorney Rosenberg that emergency means what its common dictionary definition is, and that DCYF should know what that means, the party should know, and a judge should know. There's nothing in the language that we've proposed that would inhibit DCYF from placing a child based on their perception of what an emergency is. I mean, once counsel for a child is appointed, the attorney might take issue with the the emergency assessment, and I suppose that could be litigated, but DCYF could move the child, and they do move children based on a conclusion about emergency. Emergency, in my experience, means the kid has to move,
Right. Okay.
period.
All right. Very good. Thank you.
Thank you.
Would anyone have any further comments from the attendees here? Oh, and you can get up right with her if you'd like. It just confirms that you will be heard. That's all. It's just-
Good
Okay.
afternoon. For the record, Cassandra Sanchez, child advocate for the state of New Hampshire. And as others may have mentioned prior, my office had been involved in meetings discussing the amendments that are before you today. We have been in agreement with the assessment that was put forth by the JRPG, in which this is the one with the more extensive language, in which children in residential placement or at risk of placement are able to be assigned counsel at the discretion of the court. And to just refer back to some of the other questions that were asked earlier, comments that were made earlier, I do think it's important to recognize that the research does not tell us that children being present at adjudicatory hearing is going to be traumatizing. There are many instances for some children where it will actually be a healing process for them, especially if they are able to see their perpetrator held accountable for what they have done to them. So we don't have an outstanding amount of research that says that that is a negative and impactful process for them to participate in. And I do feel strongly that their attorney should be a part of that. And have an opportunity to voice what the child wants. Like others said before me, I do believe that the judges have the ability to differentiate the fact that many children do want to go home and love their parents because that is all they know, but understand the facts of abuse and neglect and when it is safe and appropriate to remove them from that setting. I did also want to speak on the question about the CAT assessments from Representative Long. It is my understanding that now that the program has been in full swing for quite some time now, there have not been many delays in getting those assigned. They are sent out timely. Maximus has the staffing currently to be able to keep up and do those assessments. So I do believe that time of referral for the CAT assessment is critical for the notification to the court for an attorney to be assigned. There are unfortunately many times still that my office is receiving complaints from the community in regards to placement of children, high numbers of children going to residential care where there is adequate family available that has not been explored. And I think that is the critical piece of having the attorney involved from the very beginning of that process so they can advocate. And there are times that a child may get, so the CAT scores is 5 is the highest and 1 is the lowest, and there are times that a child could have a 3 or 4 CAT assessment, but residential placement may still not be the most appropriate placement for them. I have met with many children who do better in smaller settings, family-like settings, as opposed to residential treatment settings. And so although the CAT may be saying they have difficulties that need to be met at that higher level, with a smaller environment and the appropriate community-based supports, they can be more successful than being placed in a residential facility. And I do believe there are times where an attorney can adequately voice that to the court and ensure that that placement is truly being reviewed before a child is sent there. I also did want to share some of my personal experience before coming to New Hampshire. I worked in Massachusetts, and in the state of Massachusetts, every child is assigned an attorney at the beginning of the process and throughout to the end. And this was not just children in residential care, but it was all children. And I felt, even being on the other side at the time, I was working for DCF, and I felt that they were able to advocate for the children appropriately. They were able to have some of those conversations, some of those difficult conversations that came up earlier around child's expressed interest, but what's in their best interest. And from my experience, the attorneys did a very good job of ensuring that they voiced the child's expressed interest in court, but then also discussed a backup plan. So with the child, if you, yes, you want to go with mom and dad, if that cannot happen, then what? And then the child may say, oh, so-and-so relative. So then in court, they are saying, first and foremost, this child wants to remain with family. But if that's not possible and the division is going to be winning their case here, the child would like to ensure that this particular family member is adequately explored. And so they are able to somewhat represent both. And I do think that skilled attorneys, as long as they have the appropriate training to do that, can ensure that they maintain that trusting relationship with the child and truly clarify and advocate and voice for what they want in court, while ensuring that there is also an appropriate backup plan, knowing that much of the time going back home may not be an option.
Representative Long.
Thank you, Mr. Chairman. So a couple of things. So we're just talking about residential placement.
Yes.
With respect to the attorney. Okay, so not all. Now, did you say the data doesn't show added trauma to the kids, or there's no data?
It does
Oh,
not. There is the research right now does not outstandingly say that it is additional trauma to the child by being present at an adjudicatory hearing.
Okay.
There is some research in support of children attending these types of hearings.
Okay. And also what piqued my attention, that an attorney may drive towards family placement. It seems that seems very reasonable to me that could happen. And that's what you've experienced in Mass, is that instead of residential placement, they went either with a family member or somebody else.
Yes, I have had the experience where attorneys have been able to get children placed in homes, and it does work a bit different there, where the department in Massachusetts could not approve them as a foster home because of certain barriers. And it could be something as simple as the space they have in their home. And to be a foster home, it requires certain space.
Sure.
And so at that point, the attorney would advocate for the child to still go to that placement, knowing that they could provide the adequate care, and maybe would have to uniquely change around their configurations of their house to be able to fit the child in there. And so those are some of the situations that I saw where attorneys were very successful in keeping the child in a least restrictive setting with family that the state was unable to do.
Okay. Thank you.
Representative Gregg.
Thank you, Mr. Chairman. Thank you for being here today. I was hoping you would come. What is the definition of at risk? Like, is there an at risk defined here that we would be?
We did not come up with a definition of at-risk. Rather, we pointed in this amendment here to when we understand that the DCYF would be moving towards seeking out these types of placements. And as Lisa Wilford mentioned before, I was present up here, it is in their policy that there comes a time where they are sending a CAT referral out, as well as the child's case packet, they may call it, where it has all information about the child to seek out placement. And so that is what we were leaning into as at risk, because that is the understanding that is our understanding of the way in which the division already operates when they are looking for placement beyond foster care or kinship care.
That's it? No, Ms. Sanchez, I'm sorry, Ms. Sanchez. Let me make sure I address you correctly.
No problem.
The issue specific to HB 535 as introduced. What does that not do that one of the amendments that we have before us will allow that flexibility to do in meeting the child's needs for representation?
The importance of that is ensuring that children who are in placement would have access to an attorney, because we do understand these are our most vulnerable children that are in that level of care. And if we are not specifying that specifically those either in residential placement or at risk of residential placement would have an attorney, then we are missing our most vulnerable youth having the appropriate representation to ensure their needs are being met appropriately. Of course, we do have CASA in place who can advocate for their best interest, but it is really important. A point that was made before me, it is really important to ensure that our children feel they have a voice and that they are heard. This is a process where their entire life is being controlled by adults that they don't know. It's hard enough for children to adjust in a world and grow up where their life is controlled by their parents, whom they know well, and they have an understanding of what the expectations are in that home. But to have strangers who they are unfamiliar with is very unsettling. And what we see for a lot of children is when there's that unknown and someone else has control over their life, they seek out other areas of their life where they can take control. And often that does display in risky behavior.
So that, with that statement being heard, the bill as written does not provide that access to representation? As it states in here where it says it shall be entitled to representation of counsel.
It does not, because it does not specify when they shall be, and especially that piece of those at risk is not, those in placement and those at risk of placement is not clarified there, and so it leaves a lot of discretion to the court without identifying those most at risk youth.
And then one follow-up with you is the amendment. I mean, we have two amendments before us. The narrative that you refer to that would give this strength to the application of law and specific to representation. Which lines do that in the amendment? Is the amendment from the JRPG draft?
Yes, it would be in there. And we have in 2B, and it is the so down a little lower where it says such notification, so about midway, such notification shall occur prior to referral for an independent assessment or submission of child-specific information to such placement, is where it speaks about that time frame to notify the court to request an attorney, as well as that additional place down there where it says the line following, in case of an emergency necessitating immediate placement of a child, that they shall notify the court within 2 business days. And so that is ensuring that the court is notified as closely as possible and within a reasonable time frame for the division to meet that, to be able to assign an attorney. But it also leaves space for the division to act in an emergency and place a child if the only option is residential at that time. They have the ability to do that while the attorney is getting assigned.
Okay, and the reason I was bringing this up, since I'm grateful that we received this when we did, but the but is dealing with RSA 170 and not 169. And as a result, it's seeing the difference between the two. I just have 169 in front of us and not 170 to see where we're coming deficient, so that what's recommended will have the appropriate result that is being advocated here, and that's to look after our children, the minors. And I just want to clarify from a minor standpoint, there's 18 is majority age at the moment. What's the other side of that? Is it from age 1 on?
It would be birth, but our residential, if we're talking about specifically those in placement, children in placement typically range from 5 to 6 years up.
5 to 6.
Ideally, it should be 12 up, but we have seen children as young as 5 or 6 placed in residential facilities. I would like to clarify as well, the important insertion in 170G is to inform the children of their right, which I believe is very critical to include here, because and again, it's not saying that it guarantees them a right to an attorney, but it is just to inform the child and add this to the Children's Bill of Rights, because if this is a right that children have, they should be aware of that. They should be informed and have the ability to know when to ask for an attorney.
And what I was just shown by my colleagues here was the age of majority is to 21, not 18. And that's dealing with mental health challenges. So I wanted to make sure that is that concurrent with what your expertise is?
Yes, there is an extension to 21 for those
Developmental
children,
disabilities.
as well as those that choose to sign on into aftercare, but they then have some decision making power with that. But there is also a differentiator for those that have disability and are placed by schools that would actually go to 22.
Okay. And one additional question to ask, again, we want an open concept here for guidance from our professionals. We have another draft amendment that was in effect taking out a sentence. Did you get a copy of that? Or do you have a copy of that one?
Are you referring to a prior amendment that was worked on between the groups?
Well,
Or are you referring to the CASA amendment that was?
No, we just referred one
Much
today from
Okay.
CASA.
So yes, the CASA amendment does not speak in depth to those children that are in need of placement or at risk of placement. And my understanding is, as they shared today, there's some reservation around some of that defining of that and when it's appropriate for those attorneys to participate in hearings.
Okay, and just a clarification for me is when it states to represent and the word was moved from one part of the existing law to here, the expressed interests of the child. What's the definition of expressed?
So the expressed interest would be the interest in which the child is stating themselves, rather than what CASA represents is the best interest of child, which is taking into account what is appropriate for them developmentally and safety wise, which is also the Office of the Child Advocate also operates to ensure the best interests of children is protected. So those two can differentiate. That's where we're talking about those situations where a child may want to go home to their parent. That is their expressed interest, but it is not in their best interest for safety purposes to go to that setting.
And that would be also at an adjudicatory hearing.
As it stands in their amendment, my understanding is that that is not to be at the adjudicatory hearing.
And just so I'm clear myself, because it's always a moving target here, what's the definition of adjudicatory hearing?
I am one of the only non-attorneys in the room, so I'm going to pass it off to someone else.
Finally,
here.
I got a question you couldn't answer. But yeah, no, just hold right there. But yeah, I'd like to,
Yes, Michelle Margaret, New Hampshire Legal Assistant. So
Yep.
the definition of an adjudicatory hearing is the trial. So it's the trial to determine whether or not the child was abused or neglected. The amendment would allow representation at any stage of the proceeding if the child is at risk of going to residential placement. So that could potentially be either at or prior to the adjudicatory hearing if the court has removed the child from the home and placed them in residential, or there has been a request to do that prior to the adjudicatory hearing. And so there are two touch points: the preliminary hearing,
right.
the adjudicatory hearing, and then there's the dispositional hearing, which is like the sentencing, like what's going to happen going forward.
Wanted to make sure the definition hadn't changed here. But thank you very much for that. And Ms. Sanchez, we have Representative Gregg has a question for you.
So, in your experience before, you worked in Massachusetts where you had a lot of the attorneys for children. Was there also an organization like was CASA there as well?
Yes, they were not as widespread as CASA is here in New Hampshire, but yes, they do exist. They have a Massachusetts chapter as well.
So, what does that cooperation look like as far as are they still involved? Like if a child has an attorney, then CASA is still involved. I'm just looking at what this looks like if we have attorneys for these kiddos, and what does that cooperation look like?
Absolutely. That is actually a great question. They would have both. But again, in Massachusetts, they were not always given a CASA. It would be appointed by a judge. I can share, especially in the work that my office has done closely with the Office of the Child Advocate in Massachusetts, that one of the recommendations that came out from their Harmony Montgomery report was for there to be CASAs and attorneys for every child. And I think that's really critical, right? Because it is important to honor the child and ensure that their expressed interest is heard in the court. But it is also critical that their best interest be represented in the court, and a partnership between the two working together for the child is when we see the best work done and the most successful outcomes. And so with the work that they did in reviewing how Harmony was placed with her father, they recognized that in that case, there was an attorney, but the missing link was also having a CASA representation. So I do believe and hold firm in my conversations with them and their full assessment of how the court proceedings played out in Massachusetts, that it is very pertinent that we make sure we maintain the CASA program while adding these attorneys to advocate for the children.
Thank you, Ms. Sanchez.
Thank you.
Were there any other comments? What's that? Oh, there you are.
Good afternoon, representatives. I'm Erin Cregan. I'm the general counsel for the New Hampshire Judicial Branch. I thank everyone for having sent me their drafts since your last meeting, and for accurately representing what I told them, which is that, of course, the courts don't stand in the shoes of the legislature when it comes to making a policy decision. You weigh these interests and you write the law, and we will apply what you write. And we typically limit our commentary to issues of what the court can do and can enforce, and whether there is a question for us about what you are intending and what you want to have happen when the statute is applied. Typically, I would say the larger the change in the law, the better it would be to have great guidance from the legislature about what it is that you want to change and what you want to see the judges doing. In saying this, I'm not saying that this is not an issue that is extremely important to the judges that work in this area, that they're not extremely passionate, and that ultimately when you weigh all these interests, you might not find that one policy alternative is superior, even maybe vastly superior to the other. We're not commenting because it's not our place, but not necessarily because we're telling you that these are the same or that we're indifferent to the result. It is constitutionally committed to you to answer this question. Within our role of how do these things impact the courts, as I look over some of the drafts, certainly the draft that says that there will be discretionary appointments is one that the courts can easily administer. It is not confusing to us what is being sought in that draft. Looking at some of the other drafts, I think there are questions, and I think you've heard them come up in the conversation today, that there's a term that will be interpreted by the courts, that the courts will decide what this will be. For example, just taking an example of emergency, if you have a vision of what it is that you want that to be or to not be, or if you want it to be committed to the discretion of the court or committed to the discretion of DCYF, guidance from you would be very helpful. I think one of the issues that's been raised is that there are not very many attorneys at this time that do this kind of work. And so it is possible that there would be a situation where the statute calls for a mandatory appointment and there's no attorney available. If that's the case, what is the guidance that the legislature wants to give the courts on what we would do at that point? If there is going to be an attorney representing the expressed interests of the child in a hearing on their best interests, is the legislature envisioning that at some point the courts could find the express interest trumps the best interest, or are you envisioning that the express interests would always defer to the best interest? If you're not expecting that the attorney for the child would participate in an adjudicatory hearing, would they file a motion to participate? Would there be a standard, like a low one or a high one, extraordinary circumstances that would need to be demonstrated? There are questions here that I think we do have, because if this were implemented, there would be changes in the way that things are done, and we want to make sure we implement the vision that you have of how these problems should be solved, because although you can solve them by committing some of them to our discretion, we may read your silence on the issue as mandating a different result or anticipating a different result. So I appreciate all of the consideration that you've given to this issue. It is a very complicated issue. As these different groups have discussed how to address these problems, there is a lot that they have brought up for each other that I think was very productive, and I appreciated reading about it. And I think they are some good points to be made, but there are still questions that the court would have in how to implement the vision that you have for what the policy in this area should be. And so I want to flag that for you. That is our limited ability to offer information to in this area.
Representative Long.
Thank you, Mr. Chairman. You probably can't answer this now, but if we could possibly get an answer, in your opinion, do you believe this would be helpful on behalf of the judges or the court system?
When you say this,
Well, attorneys being appointed for children. Just like I asked you about the parental yesterday's, I'm looking to relieve, we already know that the judge's hands are full for many reasons, and I'm looking to relieve that. Do you think that this would be one of those aids with helping a judge determine issues?
that is a very difficult question. I do think that when I first reviewed the language about offering more types of discretionary appointment, it's hard to see how that would be harmful, because if the court ever thought it was harmful in any particular circumstance, they would not appoint. So it's difficult to see what a negative side of that would be. In terms of a mandatory appointment, it's not necessarily a negative, but if you don't have an attorney available, or they are allowed to argue express interests versus best interests, it raises questions for the judge that might be difficult to deal with. So I don't want to suggest that it would always, no matter what is provided, if there's an expansion of attorney rights, that it would be easy for the courts to administer. But certainly in terms of offering more discretion, it's hard to see how there's a downside on discretion. We just want to make sure that we would appropriately handle any mandatory requirements that you impose.
Okay. Thank you.
Ms. It's Cregan?
Yes, sir.
I want to make sure I said that correctly. Ms. Cregan, in the bill, there's a fiscal note that has all zeros in it, because but there was a very, I believe, a strong comment from the Judicial Council stating what the challenges are, and what you just recounted, if I may, is what is being stated in that section of the proposed bill.
And without speaking for the Judicial Council, they do pay for these attorneys right now, the parental attorneys who are appointed. So it's very likely their funds that would be implicated if there's an expansion of appointments. So the issues they raise in terms of availability of either funds or attorneys are certainly issues which they're poised to comment on.
And as Representative Long has stated clearly, we have a judge capacity issue to meet the cases outside of having a wait list that could go on ad nauseum, I would imagine. Would you have any guidance relative to the GAL silo of resources being expanded versus the attorney silo, when if they're not available? What is the alternative strategy when the representation is clearly needed, or there's no one there, in this case for the subject that we're talking about here, the young children?
That's a tremendous challenge in terms of funding, the limited resources that a state always has to spend, and how it spends them, and also our national labor shortage. There is no area that is not impacted by a lack of talent, a lack of people that we can attract into public service. While they're very, very desirable in private service. I was talking today and seeking to answer some questions from a hearing yesterday about Guardians Ad Litem, about our current status of the Guardian Ad Litem program, and we have not been taking in new recruits very frequently for the last few years. It has been a challenge attracting the Guardians Ad Litem that appear in the parenting cases, that are typically paid by the parties. We just have not been able to attract a lot of new people into that profession. So that is a challenge. I'm not sure that you wouldn't see a shortage in other areas as well, but we certainly do have some institutions that already exist. We have Guardians Ad Litem, we have a certifying board, we have CASA. There are structures that exist, but you're right, we're impacted by a resource and a personnel issue in many areas.
That being stated, is in passing a methodology to meet this challenge that we have without appropriate funding, and let alone if the funding's there, if you don't have the professional resources, individuals to fill that need, how are we meeting that? Or how is that being met now?
My understanding in terms of the parenting attorneys who typically appear under the statute's current requirements to appoint parents have just been decreased by about 2 that I think went to go work for DCYF. And I know that we are facing a very real possibility that we are not going to meet some of the existing mandatory appointments in the very near future. We certainly hope that won't happen. And I know that there are folks that are working on recruiting people and trying to get more talent. But that was one of the things that we notice with this proposal, speaking not at all on whether it is a good policy idea, is the courts probably will need guidance on what they do if there is not an attorney available for a mandatory appointment.
And then the unique opportunity to have you here for this. So your guidance is on reading the bill along with our professionals. Do we need to make a change on this right now? When I say right now, do we need better services for our children, families, if we don't have these other resources to support it, where it's like a false commitment unless we have the funding and to have the professionals ready to be there when the judge makes a decision for representation for the children in these family court cases.
That's a great question. You have alternatives. I wouldn't want to direct you as to how to handle those issues, whether you would want to handle one part of the issue first and then expand from there. I couldn't say the best way for you to handle that challenge, but I think it is a challenge, and it's one that I know some of the folks have flagged as well, which is you have your idea of what might be the perfect system, and you have the question of whether you would implement that as soon as possible in a well-funded consolidated measure, or whether you would try to do interim measures and work towards something which might have the advantage of giving you some feedback on what works and whether there are unexpected challenges, but also has a negative that you're not necessarily getting everything that you want right away. That is a very difficult question. I do not envy the situation that you are in implementing that change.
Well, one last point to get the benefit of your guidance on. Now, precluded with this comment, in all bills, there's a may and a shall. And in the bill as presented, it was saying that there may be a appointment, and then but at the end, it shall be, there's a shall be entitled. You're entitled, but you may be appointed. Is when we're looking at making a recommendation here, should the word shall be a standard to ensure that I call the different silos of responsibility know they have to perform, so there's not I change my mind, I don't need to do it, even though others directed you needed to, until it comes to a criteria that says if it's not available, and by available meaning for funding, and if the funding's not there to provide the resources. What's your view on that?
We certainly implement both types of statutes. We implement statutes that have a may and give discretion or wait till resources are in place. And we implement some statutes which are an absolute lock that something has to be done. It shall be done. The legislature has decided that the courts should not have discretion in that area. And some of those are extremely appropriate. So not suggesting that you would never need a shall. To say you shall appoint an attorney for an indigent criminal defendant, that shall happen. Absolutely. If you do not have the resources in place, I could see that would be difficult. So if you are going to mandate that the court shall do something and the resource is not available, I would suggest giving an alternative for what the court would do if that resource is not available.
Yeah, it's interesting what you just referred to as shall for indigent criminals, but may for children.
There are many issues like this in our law, that the requirement to have an attorney for an indigent criminal defendant is in the U.S. and state constitution. So it is not something that the legislature could choose to obviate if they wanted to. That is something that we must do, or else we will have the conviction, if there is one, will not stand. This is an issue which I understand that states have. There is not a constitutional mandate, which is not to say that one could not be passed by our citizens or ultimately interpreted to exist. But at this moment, there is not one. And so it is committed to the legislature's discretion, which again is not to say that there is not something you will determine that justice requires be done in the case. But that is a distinction legally between those two different situations.
All right, thank you very much. Representative Long.
Thank you, Mr. Chairman. So I think I heard you say that if it's discretionary, then make clear our intent. So we're getting what we intended to get. Okay, and also with respect to the effective date, they like to see the beginning, January of the following year. So any effective date should be January of 2024, January 1st. Is that give enough time? Well, it probably wouldn't give enough time. What? Yeah, it'd be 25. Okay.
If you're looking at January 2025 in terms of our training of our judges, I believe we could do it in that time period. In terms of making sure that you go through the budgetary process with regard to the needs the Judicial Council will have in funding, I would defer to you. I think you may have more information about how you would ensure that the mandates that you have are funded.
Okay. Thank you.
Thank you.
I just was going to make a comment on that. Is I found it just in the past that when there is a new requirement for spending, it's the next budget cycle. So it's what we put the policy in place, but it's moot if it requires a funding component until the budget is heard, and that's why 25, or the next budget cycle, unless there's a executive order to move money from from one location to another to fund it. Thank you very much.
Thank you.
Did we finally stimulate you to say something?
Just hit that button so we can move on.
Yeah.
Thank you so much.
Thank you. My name is Jay Bucky. I'm currently the Deputy Director of the Judicial Council. As I was saying, I don't have a name tag yet because I'm quite new, taking over for Richard Samperl, and I'll take over as Executive Director on November 2nd. And
Of Judicial Council?
Judicial Council, yes. Wanted to add just a couple things since I heard our agency mentioned. My main role today was to listen to the legislation, see what the impact would be, but I wanted to add a couple things since the fiscal note had been referenced, and just a little bit of more nuance in terms of for the Judicial Council, the degrees of appointment and what that language would necessarily mean. And I'll just start off briefly by talking about for the Judicial Council, the big difference between a right to counsel.
One moment. Are you an attorney?
Yes, sir.
Okay, Attorney, let's see, Buckingham, move that mic right to your face. Now.
Okay.
I don't want anyone to miss your words here.
Okay, thank you. As you can tell, it's my first time at this desk, so I can't. Great. So for our agency, the difference would be between having a right to counsel and then a right to appointed counsel. That would be a major difference in terms of expending resources. Just by way of analogy, the way I think it might be helpful to think about it is for people who are accused of speeding tickets, DUIs, minor misdemeanors like that, you have a right to counsel in those cases. If you can afford a lawyer, you have a right to have one in those cases. However, in a Class A misdemeanor case or a felony case, you have the right to appointed counsel, which was what was referenced by Attorney Cregan. So that would be the difference in the language that would matter for resources, because if someone has a right to appointed counsel, then obviously our agency would have an obligation to expend resources to fund those attorneys. So that language would be very important. If there's a right to an attorney, but it's not a right to an appointed attorney, our read of that would be you wouldn't have the right to have state funds expended for that attorney unless we received some other order to the contrary. In terms of funding generally, I think our fiscal note was that the funding was indeterminate, and that was because the way it's currently written is it didn't create a new right to appointed counsel. If it did, obviously that would create a more substantial need for resources. However, I would note that there would be, regardless of whether that language is included or not, anytime there's a new right to counsel or a new opportunity for counsel to be appointed, that would necessitate an additional expenditure of resources, and I think you all already touched on the need for having an additional time period so that we could seek funding and have that approved, so that would be available, and also to seek and procure additional training resources for attorneys, because that would be important. I think it's been mentioned already that there is and continues to be an issue with obtaining lawyers who provide these services and cases. Obviously, they're important cases, and having the right training and the right attorneys is also important. But finding the appropriate attorneys to take these kinds of cases throughout the state, it can be difficult. You know, there's not, especially in more rural parts of the state, it can be hard to find attorneys who will take these cases. So there is a resource issue there, and whatever the legislature decides to do, we will do our best to execute that vision. But I just wanted to provide a bit of context there in terms of the different degrees of what level of funding, what level of resources be required based on what's passed.
Thank you, Attorney Buckingham. And do you have a copy of the House Bill 535 nearby for you?
No, I don't believe I do.
Okay, well, go from memory then, maybe something you've read it, but when you were saying the difference between the right to counsel and the right to, did you say appointed or appointive?
Appointed.
Appointed counsel. That would need, you recommend that we, in looking how to move something forward here, is to put language in law that made that right, that's a definite cause and effect, that when asked, it shall happen. By how you describe it, am I, or not?
Just to be clear, I think at this point, I would just say that it would make a difference in terms of the resources necessary. So if it's written that there's a right to have a lawyer appointed, then that would be one thing. If there's a right to counsel, that'd be another thing. Oh, do I have any? Oh, sorry, I just didn't see the 536. Thank you.
Just the last, did the attorney give you a copy?
She pointed out that I didn't. I was looking at the statute, not the House bill. Excuse me.
Oh, well.
Yes, I have it.
The House bill is the authority having jurisdiction.
Yes.
Thank you for supporting that. No, just to go to the last line, well, it's three, where it says the council indicates, etc. There's two sentences right there. And it was just, where the bill does not direct the court to appoint counsel and does not include a public funding source for such representation. That's when you're providing your guidance there, that would be something that would need to be in a bill narrative to ensure that this does take place, and then would require funding to be present. Am I saying that that's what that's directing us?
Yes, exactly. So if the intent was to create a right to appointed counsel, that language would need to be explicit and have to be changed.
And by explicit, just to get your guidance here, what else would need to be added to that? Oh, and might say not to this per se, but the comment of the right to appoint counsel, and then to ensure that the funding is there, because then it's moot. Otherwise, the funding wouldn't be there to pay for it. What narrative would need to be in the bill for that to happen? Would you have a recommendation on that?
I think in the first instance, I'd probably want to take a look and consult with the current executive director and maybe provide a written response with our suggested language. Again, at this point, I wouldn't be taking a position either way, but we could certainly provide a written response which would indicate what language we would read as creating a right to appointed counsel.
Yeah, I asked that because I wouldn't want it to be, quote, under appeal after the fact, when it said, well, you didn't ask the authority right here like yourself on what would be a correct narrative should this move forward. So that's why I was asking your guidance in that regard.
Certainly, and I can also take a moment right now to consult with the chair of the Judicial Council is here as well. I could consult with her and get back to you. But I do think perhaps in terms of my preference today, since we didn't prepare a revised version, we can only point out what our understanding of the law is as written.
Yeah.
We would certainly be happy if the committee would like us to come up with language that would mandate an attorney. We could do that. Whether or not the committee should do that, obviously that's up to you, but we could certainly provide language that we think would be unambiguous.
Well, what we have the Children and Family Law is making the recommendations on this retained bill on the 31st of October. So then I ask, is that something you could get to the subcommittee
Certainly.
prior, I mean, as quickly as possible, so, and then we'll decide, when they decide what's the next steps to do
Certainly, we can get that. We can get that to you
on that narrative.
very quickly. Yes.
Right, thank you, Attorney Buckingham.
Oh, and it's Attorney Bucky, just Bucky.
Oh, Bucky?
Bucky, yes.
Where'd I get Buckingham from?
I like Buckingham a lot, but I don't know.
Well, the castle's open, I can tell you.
It does sound better.
But your last name is Bucky?
Bucky, yes.
Oh, man, I was way off. Sorry about that.
No problem at all.
Yeah, you faded at the end. You went Bucky. All right. You know, that was it. I get that right the first time. All right. Was anything further for Attorney Bucky?
Oh, no.
Okay.
I just wanted to add sort of a little context because it might help give you a sense of some of the numbers. CASA currently has 127 children and youth that are placed in residential facilities. And we estimate that we have about 75 to 80% of those total numbers of children from only involved in abuse and neglect proceedings. 127 are in residential facilities. The new director of DCYF is very committed, and I think Cassandra could speak to this too, to eliminating as many residential placements as possible and putting those kids into foster care, kinship care, or other resources within their community. So there is that movement. But just so you have some context of what the numbers of attorney representation for kids, for children and youth in residential, that's what our numbers are at this present time.
127.
127 children that are in residential placement. Yeah.
And is that in New Hampshire only?
That's New Hampshire. Well, no, some of the 39 of those children, and those numbers are about 2 weeks old, so it may have changed, but we are really working hard at getting our children who are in out-of-state placement back to either placement within the New England region or within the state of New Hampshire. So that is happening. We're seeing more kids coming home.
So, but at the moment, not.
At the moment,
it's 39 are out of state.
It's 127 in residential, whether in state or out of state or within New England. But
Okay.
39 of those are outside of the state. So just to keep that number in mind, it just gives you a sense of what potential how many attorneys we could be looking at if this is mandatory, without developing a pool of well-trained and qualified attorneys in advance of that. So.
Representative Long.
Yeah, I just, with respect to both proposals, are they replacing the whole bill? It looks like.
That was that was the
Attorney
intent.
Rosenberg's is.
That was the intent.
Okay, so
Yes.
yours is
Yeah,
also.
I think that the JRPG one just kind of amends the first section
Right.
of the original bill and then takes out the second section and replaces that second section with new language.
Right. Okay, thank you.
Anything further from all our professionals here? You're laughing already. What happened? You've had enough? Oh, geez. I'm not feeling the love all of a sudden. What happened?
It's not all crystal clear now?
If we could just talk in general without asking anyone questions, you guys have been so gracious with us on all of our questions, and thank you. You know, I have to the rest of my subcommittee here. You know, obviously this is an issue, and gosh, even there's a story on Netflix right now, Taking Care of Maya, where a girl was, you know, taken from her mom, and you know, lots of different things. And so I have concerns about cases like that, not only where kids are sometimes rightfully taken out of an abusive home, but also when they're unfortunately taken out of a home they shouldn't be, where there's, you know, a doctor may be overreacting, or there's a lot of different cases. You know, when we get into this, I keep saying this, it's like a pasta bowl. You like think you get a piece of it and then it seems to grow. At bare minimum, we have to take this 30-day window out. We have to let the judges, be able to do this whenever. I am highly concerned about, what in the JRPG draft also. I do think that we need something like that. I'm so concerned about our limited resources we have in New Hampshire, and saying shall and what that's going to do. In a perfect world, we would say, okay, every kiddo should be able to do this. I think that's important, especially if the lawyer is working in concert with CASA, or the other child advocates, because I think that's necessary. We can't only have a legal brain in there. I'm just not, I think, I don't know what I think. There's a lot of information here. I am worried about resources. And I think, am I getting that right? And you can just say yes or no, Casa. That is your one of your largest concerns about this larger one is the amount of resources that we have and that we could hang this up. And this is another, we have a lot of well-intentioned bills that come to us that in wanting to fix a lot of problems, we can make more problems. No matter how we decide to do this, especially after just hearing from judicial counsel, if we don't word this exactly right, or if we don't have a sunset kind of plan or something where we give ourselves time to build these resources, we can cause a massive problem. I do think it needs to happen. I do think that we need this representation for children, especially ones who are at risk. I think we've kind of defined enough in here, at least for me in this session, maybe not in the bill so much, about what that at risk looks like. But I do know that kids, once they get into a treatment, that's its own trauma. Once they get like in a residential treatment or whatever, whether or not we bring them back immediately because it was a mistake, or we give them a lawyer once they're there, I think that's a problem, because I think that that is a trauma right there, that particular thing. We're not there yet. And it's unfortunate that there's a divide in the people that we really do look to you for a lot of advice. And I think it's all good advice. I don't think anybody's wrong in this. I think we have a complicated system with our lack of funds, our lack of resources. Part of that is we're a small state. I don't know what it takes us to get to a final place, but I do think at the bare minimum, we've got to take off that 30-day restraint that we currently have on judges. But anyway, that's just my kind of musings, I guess, on this.
Just one quick question. The 30-day issue, where in the law is that specifically?
So right now, so you'll see it on both of them where they've crossed this out. So it's by the first, where it is. So it's by the first, gosh, I don't even have it now.
I mean, I was just looking at the,
So it's by
169.10.
the dispositional orders. So dispositional orders is usually within 30 days. That's why I said 30 days. It doesn't say 30 days. It says dispositional orders. So right now, as it stands, the judge would need to do it by dispositional orders, which is generally within that first 30 days. I don't know if there's a legal requirement that be within the first 30 days, the dispositional hearing. Is there?
Child's express interest conflict with any recommendation for dispositional orders. So the recommendation from both sides is to take that out so that it can happen prior to the dispositional orders, which is within 30 days of the adjudication.
Right, exactly. So that's the seatbelt. Yeah. So right now there's a seatbelt on our judges, and I think some judges are going above and beyond anyway. But right now that's not as clear. So that's why I say the 30 days. I would hate to think, because a lot of cases when you have abuse, neglect, you have other things, you're not going to find out in the first 30 days. It could take a few months. It could, kids, as they're away from their abuser, will tend to open up as they realize that that's not normal, quote unquote, that's because that's the only thing they know. So many things come out after that first 30 days that are imperative that we not have that on there. But anyway, that's what that was about.
Oh, well, that being said, that's in rules, because then the rules aren't here. This is showing the policy, and then there's the application of the policy. That's why I'm always wondering, where that is. But if it's 30 days, and all our professionals here have said yes, that's the fact. Then what would you recommend taking the place of that in rules? in the court's rules? Is that open-ended, or what would a number be?
Well, I'm not sure that we would need, because this is one of those cases where I think the judges who are seeing all the different aspects of the case, or as many as are getting presented to them, it's their discretion at that point, because we don't know, maybe a kiddo has been sent to residential treatment, now we're 3 years out or something, that the judge should be able to say, wait a second, we need to do this. So that would be their discretion. I would not put a time constraint. And actually, so CASA's bill, while I do think it's bare minimum on what we should do, it does actually, in 535, it takes that out, or their amendment to 535. I don't know, there's so many amendments here, but it actually takes that out. You'll see where it takes out for dispositional orders. So I don't think that we would put another time constraint.
I'm not sure if it would be helpful, but basically the CASA amendment currently 169C10, and I misplaced my glasses. The
2A.
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 The language only allows a judge discretionary appointment if there is a conflict between what the child and the guardian ad litem represent as stated interest and best interest, and if there is a conflict with the dispositional orders. And as Representative Gregg referenced, the dispositional hearing is in the early part of the case. So after the preliminary hearing and the adjudicatory hearing, the very next hearing is the dispositional hearing. There's a whole nother potentially 12 months, even years potentially, that can happen in the life of a case. So for all of us who are concerned, in cases where CASA has filed motions for counsel to be appointed, we're sometimes 3 years into the case where a child dysregulated had to be removed from multiple foster homes and then was placed in an out-of-state facility. And so even at this point, the parents' rights may have been terminated, but that 169C case is still open. So here we are 3 years later, that child wants to come home. CASA is saying we want that child to come home. We think it's in the child's best interest. But because current statute reads there is no conflict and we're beyond the dispositional hearing, there are judges who deny that motion for counsel and say, my hands are tied, we're too late in the case, and the guardian ad litem and the child agree. So, I'm sorry,
Well, where in law, I mean, specifically, because I'm not
Yep.
seeing it in, well, I'm just looking at the documents I have. What's the number and location for what you just stated? That's in law.
I just can't find my glasses. 169C10-2.
C-SEN two,
Right.
I get A. All right.
So what CASA is requesting is some of that limiting language to be stricken. And we think it's a pretty easy statutory fix. And by taking out the language that we recommend, it would give judges discretion to appoint counsel for children at any point in the case, and would give judges discretion to appoint attorneys even if the guardian ad litem and the child are on the same page. And I mean, that's the example I'm giving. Everybody agrees this child should be in a less restrictive environment, but we're filing, a motion for an attorney to be appointed, and the judge is saying, we're too far along, I can't do it.
Okay, I want to see what your comfort level is on this
Sure.
one. And that is the discretion issue for judges has been my bias in discussion, in the multiple discussions on these bills we've been seeing, is what is that in question, is how much discretion a judge has and how much should be directed by law. Is this discretion in this case, that's something discretion as to when an action would take place here, you're saying that that's the more appropriate, is to have the judges decide how quickly or not how quickly direction relative to dispositional orders notwithstanding?
Where we are right now, yes. I mean, in our cases, our judges they're there for every step of the way.
Yeah.
And we feel with the lack of resources now that the limited attorneys we have should be appointed to those cases where they're really needed. That's where we should start. And the judges, so parties, the child can ask, the guardian ad litem can ask, the parent can ask. And judges right now sitting in those cases have discretion to say, yep, and we all may be arguing to that. Yes, so where we think that's where it should start.
Okay, and as Greg pointed out, relative to this 30 days, is that to use the word discretion here, for a judge could take up to 30 days for a decision, or taking it as this, we put it right in, as you're hearing in the amendment
What the
offered?
law reads is whether or not there's a conflict with the dispositional orders, and that happens to occur at the time of the dispositional hearing. So the law doesn't reference 30 days
Oh, it
or
doesn't.
from the adjudicatory hearing. It just references the dispositional orders. So it's CASA's position, if that language is stricken, that we would get to a really good first step, so that children right now who need attorneys, and we have kids right now who really do, but there are judges who feel their hands are tied, that this law is tying their hands and they can't appoint.
And just one clarification point then is, does that indicate that time's of the essence? When you have this, taking that out, that for the sends a message to the message, that the status of addressing these issues is as quickly as possible.
From CASA's perspective, we would like this. We do think there are children right now who would benefit from counsel. Counsel right now, CASA files motions for counsel to be appointed in some cases. They're sometimes denied because of this law.
Okay.
I'm not sure if that answered your question.
So,
Representative.
yeah, clarification on the 30 days, we're looking at 60 days also. So is it placement at home? That's 30 days?
I'm not sure where the day reference is coming
Actually,
from.
169C,
15, is that C15?
yep, colon 15.
We're referencing that particular part of 169.
days if they're still at home, but 30 days if they've been taken out of the home.
I mean, I guess from CASA's perspective, the striking of the language would make it clear that there shouldn't be court. The hearings, unfortunately, are not always scheduled exactly when they should be. So having a day limitation in it, I'm not sure would be helpful.
Oh, well, you were successful.
Yeah, so I don't think that
You
there.
come on up so we hear you.
I don't think that there is a limitation on days. I think the 30 days sort of got a little bit confused because we just know that the dispositional order is within 30 days of the adjudicatory. I think we can put 30 days aside and just say that the CASA amendment would allow discretionary appointment of counsel at any stage of the proceedings. And I think we don't need to talk about the 30 or 60 days because I just don't think it's relevant to that analysis. I do just want to put forward one maybe alternative. One of the things that I've been hearing throughout this is that there's a lot of agreement on the policy of what's in the best interest of kids. And you've heard that from certainly the folks that I work with, from the OCA, and even from CASA, that there's a lot of agreement that attorneys can add value to this process, and that the issue really seems to be a resource constraint as opposed to a dispute about the policy, which I think puts us in a really good place. And so one thing I think the committee could consider is doing the discretionary appointment of counsel, so taking that first piece and making an effective date now, within the next year, January 1st, 2024, but then push out an effective date of a mandatory appointment, because I think what the concern of lawyers is that lawyers aren't going to train up to do this work unless they know that there's going to be work for them to do. And so if there's an effective date that's pushed out, that would give us the opportunity to say, lawyers, there's work for you coming in the next couple of years. Let us get you trained. Let us work with the law school. There's lots of lawyers sitting in this room willing to train up new lawyers to do this work. And so if that date of the mandatory right is pushed out, we wouldn't run up necessarily against a restriction on whether or not a mandatory appointment would actually result in an attorney, because there's nothing available, but we could work really hard to make that happen. When I hear 150 cases, the caseload at the public defender's office is 120 at any given time. I don't think that's a good number. I think it should be much lower, but we're talking about 2, maybe 3 lawyers. We're not talking, the number 150 sounds like a lot. But in terms of litigating these types of cases, there are lawyers who handle a lot higher caseloads and do a pretty good job. So I don't think it's unmanageable. So I just wanted to throw that out there as an option since I'm hearing a lot of agreement on policy.
Ms. Cregan?
Michelle Wongren, sorry.
Oh, I'm
New
sorry.
Hampshire Legal Assistance.
Oh, spell your last name?
It's WANGERIN.
Wangren?
Yes.
And just what we were provided, what am I doing? Real quick here, where it said under 169C15, hearings must be held within 60 days from filing unless the child is out of the home, and then it's 30 days.
Right, but the first part of the amendment would allow appointment of counsel at any stage. So
Okay.
it could be at the
Yeah.
preliminary hearing, it could be at the adjudicatory hearing, it could be at the dispositional, it could be at a review hearing. So I don't think, under this amendment that everyone agrees on, I don't think there's a timing issue.
If you notice on the JRPG, they actually took out the exact same thing that CASA did on the other one. So that this is something that there is an agreement on. This is not a split the baby. This is like everybody agrees. But I do think that it's a bare minimum at this point. Like it doesn't solve all the issues. I do actually like the idea of pushing out this other mandatory part to where we can make sure we're building resources. We certainly can't spring it on everybody, but it is a bare minimum start. I do like that there is agreement on that.
And the definition of bare minimum is the amendment from
CASA.
CASA.
We like to think of it as a good first start.
That's the first step.
First step.
Because start goes to a stop immediately
All
when you
right.
leave the
Good
room.
first step.
Yeah. Okay, anything?
So, yeah, if I can just
Yes.
comment.
Representative Long.
Thank you, Mr. Chairman. So I, on the other hand, I look at policy, period. Policy, pure policy. What is in the best interest of the child? I'm not concerned with what the cost is. I just need to know what the general court thinks is in the best interest. I speak to a lot of people, talking about the Sununu Youth Center. You know, it's costing us $1 million a child. I say fantastic. As long as that $1 million is delivering opportunities for that child. That child deserves that $1 million, in my opinion. So hopefully we can come to a consensus between us that we can advise the full committee and reaching a consensus to where, again, like Representative Greg said, there's still some improvement that we could do now. Not the whole bite, but not the smaller of the piece either. So I think there's some absolute best interest that we should be able to deliver to these kids.
Okay, all right, so now we'll. Would you like to hear Representative go on? Another quality decision by our staff member. Myself.
I think that we had the professionals come in and tell us what their viewpoint was. They put something in front of us that they believe is going to address issues right now that need to be addressed in the court, and I'm for supporting what I'm being given. So the larger, I'm just wondering if there's a way, like you said, to break it up, and then having the two different start dates for one and then the other. But I just want to make sure that we don't take this hard work that they've done and forget that it was put in front of us. So I would love, we have some other avenues that we can look at as far as getting the second half through. If that's not a possibility, then I would prefer to take the larger bite and address the issues at hand.
Mr. Chairman, moving forward, it looks like we may schedule another meeting.
I'd say
I mean,
yes.
I'm fine with that. This is important enough for me. I'll do 3 meetings. Okay, so we'll schedule another meeting, and we have answers coming forward, I believe, from
Well, Attorney Bucky,
Buckley.
Buckley,
Or when it's Regal, it's
Bucky.
Oh, it's Bucky? Okay. And was there questions from Aaron?
yeah.
Okay,
Oh, yeah,
super.
no, that's right. Yeah.
What'd you say?
Well, what we have, let me do that, I guess. What we have as a challenge here is there is, our deadlines, and it's only can be one amendment, by the way. Right. That we, can do. And, the 31st is for the recommendation before the committee on what that amendment, would be. And that's how, now that being said, I'll just make my comment on this. When it comes down to the financial issues, that will, well, no, we can, well, let me offer this to you. I'm one that, even though we're a policy committee, we're de facto a funding, we're a finance committee also, when we know what we don't know, what these costs would be, but that would be the excuse, not the excuse, that would be the rationale to do nothing after a bill's passed, because the funding isn't available. And, but in terms of what we saw not first, I mean, what's been presented here in our discussion is like the amendment, from the CASA amendment, is doing something at the first thing for us to offer for a recommendation to have this into a formal amendment. And then it's in terms of these other issues, which are multifaceted here, is I'd say we need a study committee for it. And the reason is because of the financial components. That's the reason. And if there's any of the policy issues that could happen without having a funding issue, so there's not a reason to delay what's being recommended. And the reason being, well, we don't have the money. Right. And I'm a little concerned on that. And then just one last comment is I had a similar thing in my previous experience dealing with the getting rid of the developmental disability wait list. And that went into a delay mode constantly, but always a quality intent, but the funding wasn't there. And candidly, I was the chair of the committee that then made it, give it a short version. Of reality, when we did the funding, had the full package, it passed, and we haven't had a wait list issue for 6-7 terms now. But it recognized is not the thing, hey, we're doing half, my words, half the job without doing the funding for it. And that's why I was looking here if there's consensus for us of what we can do policy-wise that does not have a fiscal impact by definition. And then having the study committee have the full commitment to have for next year is to have this fully funded, so that our court system is not put into a chagrin, as I call this, say, gee, we'd like to do it, but we can't, and do it, meaning appointing of attorneys or the costs that it takes for our children. So I just offer that as a concept. Well,
Yeah. So
wait a minute.
I mean,
I'm sorry, wait a minute.
Well, go ahead.
Paul?
I just wanted to remind you that it was brought to our attention that the states do have access to the federal funding through that Title IV, the Social Security Act, to help pay for attorneys for children and families.
Yeah, which
It's a
again,
matching fund.
those are things that would need to
So-
be part of the research that's done of how to get in line for that, and to make sure that the funding from the federal government is allocated for New Hampshire's needs. And you know, for what we're proposing. Well, I always use that, it's for the children, yes. Now, I understand, and but as an aggressive advocate with manners, I have found dealing with faceless bureaucrats, you better be fully loaded when you're doing it, and that's with our, I'm not trying to be funny there, but that's what I've learned over time, is make sure we're doing have that right thing, so intellectually we've covered our bases, and we have the right answers to say, here's the reason for the investment, and we want access to this funding for the betterment of all our citizens, regardless of financial ability, when they come to court. But
Yep.
anyway.
very good.
Rep. Long.
Thank you, Mr. Chairman. So I'm hoping that the general court can take a consensus on all of this stuff. Whether there's a payment coming forward or not, knowing that, first of all, I agree. If this has to go to finance is going to say, yeah, we're all set. We got the budget out, wait till 25 when we're redoing that budget. But I'm wondering if is a consensus that could be taken from the general court, a vote from the general court saying positively, yes, we agree with having attorneys appointed, a must, at some level, without the implication of a financial note. I don't know if that's ever been done. But I mean, I learned a lot today with both presentations, both sides. And I lean towards both sides. And I don't want any of that to go to waste. I like the effective date scenario. Maybe postponing the financial, finding out what feds have to offer. So implement this 1 of 24, and then take a couple of other bites that we may want to implement in 125, which would be set up. Oh, I'm sorry, 125 and then 126. It would start, yeah, the initial would start at 125, right? This one here?
Can you do that in
That's
2 parts?
what the court system wants.
Can you do a bill in 2 parts like that?
Yeah.
You can't obligate
Oh, you can't obligate another future.
the future body. They have to be part of that. That's what I've learned. Yeah.
Yeah, in
Okay,
November.
through the special committee of family court, maybe?
Commission on Family Court.
Thank you. Just a couple things. I mean, if you're considering like having different effective dates, which would be a really good way of avoiding this financial pitfall that you're thinking of. One thing to keep in mind is that if you are going to start with the discretionary appointment of counsel, then JRPG would ask that you also do something that is not very costly at all, which is to make sure that the Foster Care Children's Bill of Rights is amended to reflect that the right to ask for discretionary appointment of counsel. So, because we see those two things as going hand in hand. And the CASA amendment does not include amending the Foster Children's Bill of Rights to inform children that this is an avenue they might decide to pursue.
What's the law?
So-
Law number on that?
So that's the 170G, hold on,
Oh.
21.
Oh, okay.
So the
that's
idea,
what's at the
right, so
bottom.
the idea would be to at least,
There it is.
that's where we notify children in foster care of the panoply of all the rights that they have. If the inclination is to add this right, the right for them to seek discretionary appointment of counsel, then they should be so informed in that booklet that they get with all of their rights enumerated.
Please do, Representative Gregg.
Thank you, Mr. Chairman. So if we're not including the stuff on placement, if we're just doing the bare minimum and then the placement stuff we're kicking out a little bit, the Bill of Rights would still need to be amended because I don't see the placement.
It does.
in the first
It's
part.
not tied just to placement.
Okay.
It would say to the children, courts have discretion to appoint counsel for you. You have a right to ask a court to appoint counsel for you at any
Okay.
stage of the proceeding.
Okay.
And it doesn't. Well, and it could be clear to say that that discretion doesn't mean that the court's going to say yes, but
Okay.
right.
Thanks.
But it would at least be an accurate representation of this expansion because it is an expansion, right?
Yeah.
And then the other thing, just to throw out there is that generally, in court-appointed counsel cases, there is a cap to what attorneys can generally charge. So when we're looking at approximately 150 cases a year with like a $2,500 cap, that's a total of $325,000 for 150 cases. So it's not breaking the bank. Just so that you know. And I understand that one way of dealing with this, but the other part of this is that the 4E money, the federal money, which is there, it's not a huge amount. You should just know. It's probably around, I think we figured out it was around 12 or 14% of that cost. So it's not going to be a really huge, it can help, but I just don't want to represent that as like a huge portion of what the cost would be. It would help defray the cost. And hopefully having kids out of residential facilities would free up some money.
CASA respectfully request that you just stick with the CASA amendment that everybody agrees to. Part of the issue with the Bill of Rights from CASA's perspective is we got into the adjudicatory hearing issue that you heard a lot of testimony about. So we may get there, and I think we likely will, but for now, it's CASA's position that we should stick with the good first step of the CASA amendment. And agree to the commission? Yes. Study committee.
Division one. Yes. No, Division one is where the judicial council funding is. The judicial council would be paying the bills for these cases. Excuse me.
So the study committee, I probably should have my microphone on, would make sense. Normally I would say, oh, I don't want to kick it out because it would take too long. I do think that the special committee that we've had on the family courts has been incredibly beneficial. The amount of time it's taken would take no longer than if we just put something in and we had to kick it out because of finance anyway. So that way it would give us a clearer cut look at what we are actually looking at, get some real numbers so that, like you said, in your case, where we can then push the entire thing through, we don't have a lot of hangups here and there. So I know that I think a lot of times when we say, oh, there's going to be this special commission or whatever, I know I thought that like, that's so much time, but we're already looking at time anyway, because, just to implement this, we certainly don't want to overwhelm a system and make it, bad for people who would normally it'd flow a little easier anyway. So I think that would be I see where that would be beneficial for sure. And I think you did bring it up last time that maybe this is so big, but this is so big and we respect everybody's opinion here. And I always say it's not that we're fighting different battles, we're fighting the same battle just in a different way. So I think we are looking at this, and I want to really be thoughtful on that. So I think the commission, that would be my vote for sure to do that.
Oh, wait a minute, there was another.
I said if you wanted to know what I thought.
How many votes yes? No, it's dealing, well, I'm gonna say no, let's just clarify where we are at the moment, right now, is, addressing the CASA amendment as as provided to us here, to replace the amendment that was provided in total, to the original, not amendment, but the original bill as provided to us. And this being replacing all, it doesn't say in here, it just says amend one section, I should say one section of it. the rest of the bill, remaining the same.
Well, no, their intent is to, their intent was to replace the whole bill.
Oh, we placed the whole bill?
this,
Okay.
Yes,
yeah,
and
it
that's,
doesn't say that
that's
on
full
there.
agreement from everyone that 535 is to not go. I know, I did get that last time. That was the one thing everybody agreed on last time, was that 535 is not workable.
Oh, all right, yeah, I was looking for to replace, it just says amend and to a specific, see, I actually read what you provided, so I read all these things. All right, but that is to, replace in total the bill. And with what we have here, that's your recommendation. And that being notwithstanding comments to come right now, but that would be our recommendation to the full committee on the 31st. That's the product of our action. Number one, that's our action, and the 1A is the establishment of a study committee to be formally appointed immediately, and then we start meeting immediately, and that's also over the summer months as well.
For the next budget cycle, we'll be ready to have the full recommendation. Hopefully
Right.
We'll be able to work with everyone here, including the judicial, to figure out.
Yeah.
Oh, yeah, she liked
Hi,
it.
I'm Nina Gardner, I'm chairman of the Judicial Council, and I used to run the Judicial Council for 25 years. And I have to tell you, one thing I can tell you is we don't pass the law. Division One Finance is not expected. You know, if you pass a law, you've made a policy decision, and therefore you're obligated to fund it. Don't go down the path, from my perspective, of wishing you were doing something and then trying to get it funded. You have to sort of make the policy decision, and the legislature then must fund it. Just sort of keep that, Representative Long has been sort of saying that, and from his point of view, we will not be able to get funding for something that isn't the law. Right. Oh, I just want to say that, I did this for 25. Thank you.
Oh, excuse me, sir.
Should we meet one more time on the 25th or whatever? Or do you think we got it? I mean, I'm looking at what additional non-financial consensus.
I would say I don't think there is. I mean, what I've heard here, unless there's something to add to this, to an amendment. Unless in that
right.
regard.
Yeah, picking from the other amendment. Something that's not as critical or not. Yeah.
Yeah, that's.
I mean, I think a study committee now is good, because, you know, we want to be able to bring something forward, in the next biennium.
Yeah, and the whole point about on the study is because of the financial issue, and that's when we have the full, all the professionals participant in that, so that we don't, something isn't missed, and then it becomes by missed or overlooked, not missed. It just but it takes the time to do it instead of being under a rush like this, and have all entities spoken for, represented, and that gives the weight when the advocacy takes place before the respective committees. Everyone will be in play and on the same page and not have a conflict on interpretation. Is it a dog or a cat? We got to make sure we're on the same page. So that being said, I'm sorry, Representative Ball.
Sorry, my concern is that I go back to working in the best interests of the children, and I'm concerned about dragging it on, because how many children are going to fall through the crack, or how many children are going to not have their needs met because we're delaying putting forward something that we know that is needed. And I do agree that we have other bills that are going through that have a financial note on them, and I just think unless we have it down and we say this is what we need to do, it's not going to get done. It won't get put in the budget either. So I think I'm just in it. I would like to just move forward. I guess I'm just saying, I'm thinking about the children and what they need, and pushing it out a year, you just have to wonder how many children are not going to have their needs met, and be represented properly. I would be in favor of pushing it forward and letting the full committee make a decision.
Well, I'll offer one thing in that regard. And just looking at the amendment that we have from CASA here, it is stating a relative, in representing the express interest of the child as it states here, is that the appointments will take place. The question will become, in how many cases you have, is will there be the money to pay for that attorney to do it? And if it's not there, it ain't happening. So it's and then we'll be saying, well, we'll hope it happens, because if the funding isn't there, it will not take place. You know, so in looking here is at the least, it's saying when they say may appoint an attorney, that's going to be driven by a value judgment based on, okay, who are we hiring, and then what's the cost of that hiring, and does it fit within the current budget that's available? And so this is looking out after the children, and I joined with Ms. Ball. I said I'm a Representative Ball, but here I have the same commitment to it, looking after those who need assistance and doing it now. But what I'm not one is to say passing a bill and then it doesn't have the tools to effectually apply the bill. In this case, the cost of the service, and so that's what I'm looking here is how do we get this started so that there's a commitment to a resolution and not a constant battle of where the funds come at any given time. On this, Representative Long.
Thank you, Mr. Chairman. Yeah, I mean, I'm feeling like I'm not doing all I can, is the way I'm feeling. And I agree that pass the policy and then let finance know that this is what we're looking for. You know, I don't know, if I'm on finance, I'll find it, but I'm not on finance, so it's your job to find it. You know, because I get that scenario. I've had plenty of bills pass where finance just says, yeah, we don't have the money, and the money we do have, we're not going to put towards this. And I had to accept that. But at least I gave them my opinion. Or the state gave them their opinion. The policy committee gave them their opinion. This is what we need. You know, and there's a couple of advantages, I think, for the children with respect to the appointment of attorneys that I agree is gonna be give the state of New Hampshire better situated with helping giving these kids opportunities. So yeah, it could be a discussion in the full committee, I guess, because you know.
What
So-
what can we add from if I may the
From the other,
PG on that as part of the
Well-
CASA draft amendment, and what else
Yeah,
policy wise
yeah,
would you recommend?
I mean, actually, I like the option of the effective dates. I think that's helpful. And I need to confer with JRPG to see what would be not the major controversial issues, but something that will allow us to get the general court to agree to have a stance on some issues that we want affected.
Necessarily for the controversy, but for the financial impact.
Right.
Because it would allow for, before the mandatory appointment started, which is essentially what paragraph B, it would allow for that piece of it to go through the budget, to get funded, and then for the bar to build up the attorneys to actually do this part. And so it would relieve some of those administrative constraints that you've heard about and enable this to move forward in a way that if a judge appoints, there will be an attorney to take it. We think that there will be a great opportunity to do that. And so, but again, you know, if there's a study committee, my worry is that there's no statement of policy, there's no money attached. Who's going to come to a training to train up to do this work while we're waiting to see what happens next year, and if there's going to be a job for folks who want to do this work? Because there are a lot of attorneys who love representing kids. There may be fewer attorneys who love representing parents, but there are a lot of attorneys who love representing kids. And if they have this work, we think they'll come if they're properly trained.
Yeah, I personally, the study committee, I sat here for a couple hours and I went through a study committee. I know much more than I've ever thought I would know. And thank you for that. So I agree about the study committee. I don't believe it's a study committee needed. I think the general court needs to set policy and let the finances roll wherever they're going to roll. It's not out of, it's not in the hands of CFL. So yeah, so I think there's, I just want to make our stance stronger. Cause I feel that I'm not 100% in it. It's not a Band-Aid, it's substantial, but not as substantial as I think it could be.
I mean, what you could consider is in the like a phase in, you have the discretionary happen, is I think it couldn't occur before, depending when it's passed, before January of 2024. Is that correct?
Yes.
And along with that, you could,
It's 25.
Oh, it's
20
25, I'm
20
sorry, yeah.
Okay, 20, and then you could have the, at the same time, the change in the notice to the children and the Foster Children's Bill of Rights. And then you could have the right to counsel. Now, and I have to say, this is limited. Remember, we're only limiting the right to counsel to children in placement in residential facilities or who are at, very imminent risk of that situation. That you could have kick in like July 1st of 2025, because then you're in the budget year. So then it could be included in the 2025 budget. Does that make sense? Did I get it wrong? Yes, I got it wrong, or yes, I got it right? So if they pass the law and the effective date is July 1st, 2025,
Yeah.
listen to
Yeah, the
Ms.
next
Gardner.
budget,
She
the next
knows her
budget
stuff.
is in 25. The next budget discussions will begin January of 25.
But again, no law, no funds.
No, right.
They're not gonna
Right.
fund something that isn't
So,
law.
so we could do July of 26, but we can't tie another legislator.
That's right.
January 2025.
The one hiccup for CASA was that we don't have the resources. We don't have the people.
That's
That was
right.
their one hiccup.
Right.
Do we think that we could get enough people to have the resources? I mean, I'm all for it.
Yeah,
We have the
I think
resources,
they
I'm
will. I
all
think
for it.
Michelle, I agree with Michelle. I think people will step up.
Okay,
For representative.
then I'm good to recommend it. Yeah, I mean, that's, if we can have people, that's fine. But I think we do need to take into account with what, Mr. Bucky